This wasn't you driving?
No.
Well, I can't, listen, here's what I can do. Can you post $237?
No, I was coming here to take care of trying to make a payment plan.
Well, why would you make a payment? Listen to me. This is a courtroom right now, okay? It's a courtroom. Why in the world would you come in here and ask me to give you a payment plan if you weren't the one driving?
Because I have a
Did you hear what I said?
I don't want the warning. For my rights.
Hang on. Were you driving or not driving?
I was not driving.
Why would you come in here and ask for a payment plan if you weren't driving?
That's what the officer said to do.
The officer said to come in and ask for a payment?
Take care of it.
Slow down. What officer?
I was pulled over yesterday in a car and they ran my name.
Did you tell him or her that you weren't driving on this date?
Yes, and they said to come to court, open court to take care of it, and that's what they
No,
told
I thought you just said the officer told you to come in here and make a
me
payment.
to take care of it. Yes, that's what I'm here to do.
Ma'am, I need you to post a bond. I'll be glad to entertain a motion to set aside default, but the rules are the rules. And you have to file a motion. And it doesn't have to be lengthy. They have them down there and post a bond equivalent to the amount of the judgment, which right now is $237. Are you still maintaining you weren't the driver?
Yes,
You have a credit card you can put this on?
no, I brought $40 to make a payment. I don't have it.
Why would you listen to me? We don't live in Russia. I know it's just a civil infraction, but you don't come in here and start paying tickets if you weren't the driver. Now, your friend's going to have a problem because she's going to get charged with false information to an officer. You understand what I'm saying? You post $237 within 7 days and you fill out a motion, I think it's seven. You post 230, go borrow some money. Come on back. File a motion to set aside the default judgment. Okay? You can go right down the hall. I'm not taking your $40 now. Save that for towards your 237. Okay? You shouldn't be coming in here. You don't want this up. No, it's not. Come on. I hope you guys people have more confidence in the judicial system than that, where they think if somebody uses their name and writes their friend a ticket and the friend doesn't, boy, I hope you're still friends with this girl?
Well,
Are you still friends with this girl?
friends with me.
Well, how can you be friends with somebody that just got you in trouble by giving false information to a police officer? I'm just telling you, I'm not going to give you advice on who to choose and not to choose as friends, but somebody did that to me. Get out of my house and evict if you have to, and you're done with me. What kind of friend is that? Who needs enemies if you got friends like that? 237, post it within 7 days. Come in, file a motion. Okay, good luck to you. I wish you well. Listen, we're going to treat you fairly, but you have to write in the motion that this wasn't you and you just found out on January 12th when the officer pulled you over, okay? Make sure you come back with that money. Good luck. LBNV versus Thomas Hageman, 2503867.
Good morning, Your Honor. Trevor Stratton, P65124 on behalf of the plaintiff.
Good morning. Mr. Hageman, your name, sir?
Thomas Hageman.
All right.
Good morning.
We're going to conduct what, a pre-trial today? Is that what we're doing?
We don't need to, Your Honor. This case is resolved. I personally am in possession of Mr. Hageman's signed consent judgment. So we can file that on e-file today at some point.
Okay, is that true, Mr. Hageman?
Yes.
Okay, so you're going to file that today, Mr. Stratton?
Yes, Your Honor. Someone will file that today.
Okay, I guess I need you to state your name. I don't know if you did. Maybe you did and I missed it.
Mine, Your Honor?
Yeah, maybe you did and I missed it.
Yeah,
don't
I did.
know.
That's okay. Trevor Stratton, P65124.
All right, send it over. You guys are all set. I wish you well. Thank you. Jeffrey J. Twardzik versus
Judge.
Priority Waste, 2503946R.
Good morning, Your Honor.
Good morning. Mr. Twardzik, your name?
Jeffrey Twardzik.
Where is somebody from Priority Waste? I don't see
Your
any.
Honor, they have not checked in this morning.
What
And I
the
know this was
schedule-
a review, so I wasn't sure if,
Review for what? Did we not get a judgment when we were supposed to get a judgment?
no, I believe there was an arrangement or an agreement that was made. We were waiting on
Did we get the
parties to
paperwork? Did
exchange.
you sign the paperwork yet, Mr. Twardzik?
Your Honor, I did not because I have not received payment yet, and I advised that to the attorney, Mr. Dillon.
Call Priority Waste. I want him online, please, Jennifer. Zeal
Okay, I'll call
Credit
Mr.
Union
Dillon.
versus Carrie Moore, 2504152. Did you get a hold of Ms. Ford, Jennifer, or Lisa?
She's here.
Yes, he just walked
Okay,
in.
good. Do I have somebody here from Zeal?
Yes,
Ms.
good morning, Your
Solomon,
Honor.
Good morning.
Yep.
Your name?
Alexis Solomon, P87454, appearing on behalf of plaintiff.
All right, Ms. Uwe?
Good morning, Your Honor. Jocelyn Uy, P64890 on behalf of the defendant.
Good morning to you. Today is the date scheduled for pretrial. Do you guys just want dates or did you resolve it?
We would just like dates, Your Honor. We are resolving. We're in settlement discussions right now.
Allenson too.
Can I have a pretrial order, please? Or do I have them up here? Oh, here. Okay. All right. So let me see here. Is there a defense to this, Ms. Uy?
Your Honor, it's the intent of the defendant to make the repayment plan. We're just trying to iron out the final
Can I just
details.
set this for trial or do you guys want discovery?
I'm gonna leave that to
Discovery.
plaintiffs.
Yeah, discovery if possible.
All right. Discovery cutoff will be on March the 1st of 26. No ADR, no motions date of trial. All motions for summary have to be filed and heard not later than 20 days before the trial date. No jury. We're going to give you a trial date in latter part of March. I'll put down estimated time for trial 1/2 hour, and you do have to file your witness list by February the 6th. So February 6th, the 26th witness list due. You don't have to file a trial brief. If you choose to file one, you have to file and exchange it not later than 7 days before the trial. And I also have, let's see here. Deal, let's see. What's the trial date gonna be? End of March, I'm thinking,
Judge, April 7th at 10:30.
April 7th at 10:30, okay? So I'll
Thank you,
send
Your
this
Honor.
out to you guys. And you need this part.
No.
Okay. So we'll send this out. Anything else, Ms. Solomon?
Nope, that's it. Thank you very much, Your Honor.
How about you, Ms. Uy?
No, nothing else, Your Honor.
Sorry.
Thank you.
Katie, here you go.
Hello?
Yeah. Hang on one second, Mr. Dillon.
Okay.
Jeffrey
Sorry.
J. Twardzik versus Priority Waste, 25034-03946R. Mr. Dillon, your name?
Alex Dillon on behalf of Priority Waste. Your Honor,
Mr.
we're
Twardzik,
sending mail-in
Hang
check
on.
out. He'll have it by Monday.
why are you guys waiting so long? When were you here last? Mr.
because-
Twardzik, I need your name.
Jeffrey Twardzik.
Just because of bookkeeping and the holidays and being behind, and it's not, I'm just waiting.
I'll adjourn it 2 weeks. This is a review hearing date again.
Okay.
So
Mr. Schwartz,
Jennifer,
we're sending you the entire amount to you. You pay who you like, okay?
That's fine.
what do you have for me, Jen?
The 27th at 9:30.
Remember, that's the day I have court to school, right?
Yep. Yep.
Okay, 27th at 9:30. Thank
Okay.
you both. Have a good day. Thanks.
Appreciate it. Thank you.
First National versus John Kovacs. First National, are you ready on yours? What are we doing on that? Okay,
Ready, Your Honor.
let me take this one first. First National versus John A. Kovacs, 240424. Mr. Kovacs, you have to start your video, please.
Yes, sir. I was just trying. Sorry.
That's fine. Your name?
John Kovacs.
And Your Honor,
What
for
did
the
I
record,
do last time, counsel? I reinstated the case.
I don't think we did actually, Judge. I think we were waiting to see if the defendant would file bankruptcy. He had, again, Albert Kim, P70301, appearing on behalf of plaintiff. We appeared last, I believe, in earlier mid-year sometime. I can't remember the exact date, but defendant had a bankruptcy order where he was not permitted to file bankruptcy until November. He didn't do so, so we refiled our motion. He has since filed bankruptcy as of January 9th, so our matter is resolved.
So you're going to present an order staying the case, right?
Stay in the case. I believe it's already stayed, Judge. I think this motion was to reinstate. I don't think we ever reinstate it or no?
Well, you filed a motion, I think.
And I think we've decided to hold off on it just based on the fact that he expressed intent to refile. So I didn't want to come back here again. And of course, just took a little bit longer.
Wait a minute. I thought we were up for a motion to reinstate.
We were, Judge. And again,
So now he's filed bankruptcy, right?
Yes.
So you still need to file a motion, bankruptcy stay order, right?
I'll get one to the court then. Absolutely, Judge.
That's what we'll do. File your bankruptcy stay order, please. Thank you very much.
You have a great day and Happy New Year, Judge.
You too. Same to you guys. People against Peter Flash the fourth. 25F2726113. All right. Good morning, Ms. Ford. How are you? Okay.
Opportunity to be.
Sure, your name?
Peter Lockwood.
All right, go ahead. I'm sorry.
Gave us this opportunity to return because I tried to get a deviation report to Gary Bresnan. I had the wrong email. I did. Thank you. As a result of the adjournment, get it to him. And he responded that he could get in a drug treatment court if we could get him in, and has to plead to the third. My client does not want to do it. He wants to waive the exam, and we'll file out. Just to let you know, my client had to take a blood test because he said he was diabetic. So I think that we have some technical defenses that would probably be better off in the evidentiary. And it's been 20 years since he had his.
So they wouldn't give you the,
Because he has an automatic rule if you have more.
he has what?
Well, I guess it's his policy if you have four.
Oh, he had four,
It's four.
but they were a long time ago, weren't they?
No, you remember well. The last one was 20 years ago.
Yeah. Well, I mean, the idea is to get people some help. I'm sorry that he wouldn't do that. I'd have loved to have had him. I'll go ahead and take the waiver. Call in the,
You just say whatever I think is best.
call in the prosecutor, will you, John?
I was going by my client, what he wanted.
Yeah. So that's what you want to do, Mr. Lash?
Was it probably under you?
Not if there's a waiver.
No, if he entered the treatment court.
If he was doing it here, but they're not offering him that, right?
Yes, they did. In my opinion, they did.
I thought you said they didn't.
No, they offered him if he pled though.
Well, you said plead to OWI 3. I can't take a plea to OWI 3
I'm pretty sure, yeah. And then I could get him in a treatment.
in Detroit.
Yeah.
Yeah, so I'm just disappointed that they're not gonna do it here, but that's neither here nor there.
Well, up to remain.
So, All right, let me just get the prosecutor in
You did
here.
the state prosecutor, right?
Yeah,
Shibano.
Ms. Osmaro, right?
Right.
Just give me 1 second. All right, so sir, in the meantime, your lawyer is telling me that you wish to waive your right to an exam. Is that true? If you waive your right to an exam, you're waiving the requirement that they prove that the crime was committed and that you were the one who probably committed the crime of OWI-3, and you'll automatically be bound over for further proceedings to the circuit court. Do you understand that? Mrs. Morrow, your name?
Good morning, Your Honor. Not to me yet, as on behalf of the people, BAA Corner.
Good morning. Listen, you did a no objection a waiver form last time. I'm going to need you to do one today. You don't have any objection to the waiver, correct? Can you write that up and send it in, please, real quick? So, sir, you understand everything that's going on here. You understand you're charged with a felony. If you waive your right to an exam, I'm sending you to Detroit for further proceedings. Anybody force you to give up your right to a preliminary exam? All right. Counsel, can you write that up for me, please? Oh.
You would plead to a third here.
He can't plead to a third.
It downtown. Then if I found them.
Your Honor, we did this in Westland about 2 weeks ago. When I spoke to Gary Bresnahan, he's the APA who deals with all of our OWI thirds.
Right.
I did mention last time, he has a kind of a list of things that he looks for when giving offers for OWI thirds. One of them being it has to be a true third, because this was his fourth, he did automatically deny it. But he also did mention, and again, we did this on a case in Westland, he pleads to an OWI third in the district court, but he gets sentenced in circuit court, and then that's if the court allows him to come back and do some.
Just let him plead in circuit. Why would you not have him plead in circuit? I mean, it makes no sense to me. If he's gonna, if,
Come back for Supreme Court, but that's.
well, they can take it back. If they want to reduce it there, you can tell the judge, whoever it is, will be happy to entertain it, as long as I approve of the terms and conditions.
Thank you.
Okay, I'll be happy to take it. But I'm going to approve of the terms and conditions if there's a plea. So I don't want a circuit judge saying I got to give 120 days, or because I've gone over this on and on ad nauseum with the prosecutor's office. They want to say if they're, and I'm thinking that they're coming around. But I'm not going to take a plea if it says judge has to give a year if they're convicted of a crime, which would include expired license, improper plate, and silly things like fishing without a license. I'm not doing that. So if they want to conditionally send it back for my approval, I don't have a problem with that. Okay?
I understand, Your Honor, and the only reason we have that done as an OWI third in a different district court, Westland, was so that offer could stick with APA Gary Bresnahan, opposed to going down to our general trials where another prosecutor will be the one to make that decision. So
Well, if they pleaded to OWI-3 down there or here, I don't have any jurisdiction anymore. Right? How can I handle a felony down there? I'm not a regional treatment court. No, I don't. I'm serious. There's regional treatment court in Taylor. I can't do that here. If it's pleading to an OWI-3, that's beyond our jurisdiction. If he's pleading to an OWI-2, that's within the framework of our jurisdiction.
I understand, Your Honor.
So, but I'm saying if they decide to plead to impaired 2 or OWI-2 and they want to remand and I approve of the terms and conditions of the sentence agreement, I don't have a problem taking it back. But I'm not taking it back if I don't approve of the terms and conditions. So they can figure out how they want to do it down there. Do you understand everything that's going on? You have a charge of operating while intoxicated third, which is a 5-year felony. Our jurisdiction only goes up to OWI-2. I could take the plea, have you go downtown, get sentenced there, but it makes no sense to me here. None. Zero. Zip. Go down, let your lawyer work it out with the prosecutor. They've got a treatment court down there. This just took too long, you guys, really. I mean, so if you guys want to, but I want to be clear, I'm not taking back a case on remand unless I agree to the terms and conditions of probation, however they want to do that. Okay? All right. So you understand that you're going to be bound over for further proceedings to the circuit court.
Yeah.
And you understand that's a 5-year felony. And you understand you're waiving the requirement that they show that the crime was committed and that you were the one who probably committed the crime. Anybody forced you to give up your right to a preliminary exam? All right, I'll accept the waiver. PR bond is continued. AOI date will be January 27th. I still need you to put a form in here saying no. You don't have any objection to waiver, right?
No,
Pardon?
no, Your Honor.
Okay, good enough. That's fine.
Would you like me to go right?
Nah, don't worry about it. As long as you state it on the record. Thank you.
Thank you for your patience. and-
No problem.
Thank you.
Good luck. Have a good day. Good luck to you, sir. I hope this works out. Gustavo Cesar Velazquez, 25B149, 56R. Come on up here, sir. Your name?
Gustavo Velasquez,
How you doing?
pretty good.
You're doing the right thing coming in. Thank you. You're one of the guys that actually takes me up on this. You need more time to pay?
Yeah,
How long?
just one more month and I'll be able to come in and knock it out.
Time to pay extended until February the 15th of 26. You did the right thing coming in. February 16th, okay? Good luck.
Thank you. Have a good.
You too. Miller. Michael David Miller Jr., 256W729913. They ready on this? Good morning, Detective. Your name?
Detective Sergeant Robert Vespremi at the Woodhaven Police Department.
Raise your right hand. You solemnly swear affirm under penalties of perjury the testimony you give in these proceedings will be the whole truth, so help you God.
I did.
Okay, go ahead.
Yeah, on November 9th, 2025, at approximately 0110 hours, Officer Nicholas Mitchell and Officer Kyle Emery were on patrol in fully marked unit, Woodhaven Unit 1212. Officers observed defendant Michael Miller traveling on King Road near I-75 in a black Ford F-150. Officers noticed that Mr. Miller was not maintaining his lane. Officers conducted.
It's not what? I'm having a little hard time hearing you real clearly. Can you get a little closer? I didn't hear that last sentence.
Yeah, can you hear me better now if I speak
A
up?
lot better.
Okay. Officers noticed that Mr. Miller was not maintaining his lane. Officers conducted a traffic stop and made contact with Mr. Miller. Officer Mitchell stated that he could detect the overwhelming odor of intoxicants coming from Mr. Miller's person. Mr. Miller was requested to do field sobriety evaluations, which he then attempted. Mr. Miller was then requested to perform a preliminary breath test and he refused to do so. Officer Mitchell indicates that based on his evaluations of Mr. Miller, that he believed Mr. Miller was under the influence of alcohol. Mr. Miller was placed under arrest for operating under the influence. While at the police department, Officer Mitchell read verbatim the DI 177 to Mr. Miller and requested that he submit to a breath test. Mr. Miller refused by stating in quotes, no. A blood search warrant was completed and signed by Magistrate Mastro Giacomo from the 27th District Court. Mr. Miller was transported to Henry Ford Hospital where RN Jennifer Finley drew 2 10-milliliter vials of blood from Mr. Miller. Mr. Miller's blood was sent to MSP lab for analysis. On December 2nd, 2025, lab results indicate that Mr. Miller had 0.282 grams of alcohol per 100 milliliters blood. Should be noted, the defendant was previously convicted of operating impaired on August 25th, 1998 in the 36th District Court and operating under the influence of liquor on February 28th, 2002 in the 33rd District Court.
Based on your sworn testimony, I find the crime OWI 3 was committed. There's probable cause to believe the crime was committed by the defendant and authorized the issuance of the complaint warrant. I'll note that you signed the complaint. You dated it the 12th because it was sent over yesterday. I'm just changing the date and initialing the date change to the 13th. Is that it for you?
Yes, that'll be it, Your Honor. Thank you.
Have a great day. Thank you.
Yeah, you too. Bye now.
Farouk Kazanovich Islamov. We have Trent out there, John.
Is that for schools? Just about there.
Yeah. All right. Good morning, Sergeant. Your name?
Detective Sergeant Mark Driscoll, Trent Police.
Raise your right hand. You solemnly swear affirm under penalties of perjury. I'm gonna have to, yeah, there you go. You solemnly swear affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole truth. So help you God.
Yes, Your Honor.
Okay, go ahead.
1 second. On December 27, 2024, at approximately 01:58 hours, Trent police officers were dispatched to 96 Superior Street in the city of Trenton, County of Wayne for a possible domestic violence complaint. Sergeant Nathan Pugh and Sergeant Margaret Stadler arrived and met with the caller and victim, Brenda Ada Martinez. Miss Martinez stated her husband, Farouk Kazanovich Islamov, a white male, date of birth of 4/22 of 1985, got into an argument and Mr. Islamov slapped her several times in the face and different spots on her body. Officers observed scratches on the left side of her face, near her left eye, along with her chest and upper arms. Mr. Islamov had fled the scene prior to officers' arrival. That's it, Your Honor.
Based on your sworn testimony, I find the crime of domestic violence was committed. There's probable cause to believe the crime was committed by the defendant and authorized the issuance of the complaint warrant. Dating it January 13th, setting a cash bond, and ordering he be arrested. You're all set. Have a good day.
Thank you, Judge. Have a good day.
Okay, what else? I have Zeal versus. What other one do I have out there, Jen?
There's a small claims,
We have the small claims. What's the name of that?
Mawadi. It's Michael and Carlos Medina.
Okay. Muwafi Michael versus I'm sorry. It's Michael Muwafi versus Carlos Medina Cartagena. Your name?
Michael Muafi,
Your name?
Carlos Medina.
All right. Today is the date scheduled for a small claims hearing. Did you get this work done by somebody else?
No. Yes, sir.
Today is the date scheduled for a small claims hearing. Each of you have the right to have the case removed to the General Civil Division. This is small claims. If you proceed in the small claims division, you're giving up rights. Plaintiff, you're giving up the right to seek in excess of $7,000. Both parties are giving up the right to appeal my decision, to hire a lawyer, and demand a trial by jury. You don't have to give up those rights. If you want to preserve any one or more of those rights, just tell me. I will remove the case to the General Civil Division, in which case you can appeal my decision if you don't like it. You can hire a lawyer if you want to. You can demand a trial by jury, and to the extent that plaintiff might be entitled to it, you can seek in excess of $7,000. Do you understand everything I just said, Mr. Malafi?
Yes, Your Honor.
Mr. Medina Cartagena?
Yes.
Do you wish to give up those rights and proceed here, or you wish to have the case removed? Mr. Malafi?
Like to continue.
You waive those rights?
Yes.
Mr. Medina Cartagena? Yes, what?
Yes, I would like to continue.
You waive those rights?
Yes.
John. 30 seconds or so. Raise your right hands, gentlemen. Either one of you have a witness? Anybody? Yep. No? No? Raise your right hands. You solemnly swear to affirm the testimony you'll give in these proceedings will be the whole true self you got.
So,
Okay. I don't understand. So it says defendant was hired contracted to renovate 2 bathrooms, raise existing vanity, and paint it white for both bathrooms. He was paid through Zelle $8,000 and has since abandoned the project. I sent a demand letter wanting to resolve this matter out of court. However, the defendant has continued to ignore my attempts to resolve the issue. So did you paid him $8,000?
yes, I did.
You agreed that he paid you $8,000.
Yes, sir.
Was the contract, how much was the contract for him to perform this work? Do you have a written contract, gentlemen?
So we have something that is sending for me to sign.
Did you sign it?
Yes, I did.
Hand it up. Now, what does that say? Sir, how much is the contract price?
So it was, so we were trying to do more work. So we're doing the 2 bathrooms and later on we're to do the basement. So we agreed on $8,000 to do both bathrooms.
Wait a minute. I don't know what this means. He's got basement bathroom.
Sorry, Your Honor.
Hang on. Let me just talk. Summer project 2026, 1,800. Is it right that that's not included in this portion? Master bathroom room, 5,000. Guest or kids bathroom, 1,800. So was the contract for 6,800?
Plus material. I bought the material.
Why would you guys sign something on contract to perform work that you're not even gonna start until this summer? Right? Gentlemen, here's what I need you to do. How much do you think you completed the work? Yes or no?
Okay, I need to speak something that he gave me. That's not the invoice, correct? And he did not sign. So the invoice is actually the one I gave him last, which was $6,800.
Okay.
And that I have all the payments through the invoice from this invoice, not from that one. And that sign and that signature came from him after, not from the system. So the actual, it was a master bathroom and a kid's bathroom.
Right. I mean, it's pretty clear that that's what you guys were.
Pictures of the master bathroom finished.
Hang on. It's pretty clear that's what you guys were doing. 5,000. You got 5,000
For the master bathroom.
I know. And 1,800 on the kids' bathroom, right?
Yeah.
Okay. He gave you 8,000. Let me see your invoice. It's just on a phone?
Yeah, I have everything digital. Same thing with the receipts of the Home Depot, everything I purchased. Because he gave me 2,000 at the beginning was for material. So the 8,000 was 6,800 plus the 2,000.
He only gave you 8,000 though.
Yeah, but the 2,000 was for the material. I have all the receipts that was sent to his house.
I know. So are you saying he's light by $800?
That's what the system says here.
You wanna have all the money that I sent to him?
Wait a minute.
Yeah.
But you agree that you sent him 8,000, right?
Yes.
And he's saying that you owed 6,800. Let me see. You guys, okay, good enough. So $8,000 defendant or plaintiff sent defendant. Defendant says he's entitled to 8,800. Right? So 800 more, right? You completed the work, right? You completed the master bath, you're telling me, in the guest room, right?
No, the guest bathroom was never,
How much work do you think you did?
we never started the guest bathroom because we came into this situation.
All right, did he complete the master bathroom?
He did not.
Did you get an estimate as to how much it would take to complete the master bathroom?
It was word of mouth. He said probably about a week he'll be able to be done.
Wait, slow down. Keep your voice up. I'm asking if you got an estimate from somebody else.
No, I haven't.
Well, how are you going to prove a case here? I don't know how much work he did toward the master bathroom.
I have pictures.
I know, but yeah, listen, you show me pictures, that's fine. I'm not going to sit here and say it would take another 2,200 or 1,400 or 3,900 to complete the master bathroom. You're going to have the master bathroom completed, right? Or not?
Yes, we'll have to have it done. Right now, it's not operable.
Right now, it's not
Yes,
one?
it's not operable. I've never used it, but since he did the work, I cannot.
Well, that's what, but here's what I'm trying to tell you nicely. I'm not saying you did or didn't complete it, Mr. Medina, Cartagena. I'm not saying you did or didn't. I am saying that you need to have somebody else come in. Because you agree that you didn't complete the master bedroom, right?
I completed the shower, which
I didn't ask you that. I did not ask you that.
Your Honor, we agreed for the shower to be done, not the full bathroom. He knows that. He's giving you a wrong invoice.
Oh, wait a minute. Okay, let me see what you got. Is there a way that we can get this down to you, Jennifer, where you can copy this? I don't want to be looking at
If he can email him from his phone, I can
Go
print
down
it
to
for
the
you.
civil department and she'll tell you how to email it. She can print me out a copy.
Absolutely.
And if you got anything else, email it to her. So you guys go down to the civil department and I'll recopy this. My inclination is though, if you don't think it was done, completed like he does, but I can tell you this, Mr. Medina, this invoice, the old one, and I'm not saying it's part of the new invoice that you're going to go down and print off or email the civil department. It does say install new vanity double sink, add 2 water supply, install shower door, install 2 lights in shower, change exhaust fan and mirror update. Maybe the new one doesn't have it. Go down the hall if you would, please. Email it to her and you guys come back, okay? I think I'm gonna end up telling you, we need to adjourn this so you can get another contractor out to give you an estimate as to how much, if he didn't complete it, that it would take to complete it, right?
Yes.
Okay, so go down and do that. Either way, come on back up here, okay? Young, Michael Ramon Young, 25T717307. Is Michael Ramon Young out there?
Judge, is this in custody? I don't.
Yeah, I believe so. He's in
Okay, is he
custody.
at Trenton? Because Trenton's out there, but I
Yes.
didn't know we had any.
Yes. Well, Mike, do I have a lawyer here? Okay, Michael Ramon Young, 25T717307.
Good morning, Your Honor. Attorney Corey Westmoreland appearing on behalf of Mr. Young.
Morning, Mr. Westmoreland. How are you?
I'm well, thanks. How about yourself?
Not too bad.
Good. I waited for you the other day.
Yeah, I know. That was my fault.
Oh,
Listen,
okay.
if you get a minute, I'll talk to you today. But
Yeah.
you're coming Thursday by Zoom, right?
I will be in Breckenridge.
Well, I'd like to talk to you then.
Yes. No
Okay.
problem.
Breckenridge, skiing?
Yeah. Well, my roommate from law school lives out there, so we're going to visit him and wife's
Nice.
birthday and going skiing. So
Nice. Very nice.
nice little getaway.
Right. Are they out there? Do they know we're out there?
There was a officer's.
Do you have another case down there?
No.
Hey, guys, we're out here. Do you know that?
One of the prisoner.
I was gonna say, you might be distracted. I know that. Just stand right here in the red X. And then just make sure
Mr.
you can speak up so the
Westmoreland,
judge can see you.
your appearance again?
Attorney Corey Westmoreland appearing on behalf of Mr. Young.
Mr. Young, your name?
Michael Young.
Detective, your name?
Detective Corporal Sean Shapaniak, Trenton Police Department.
All right, this is a malicious destruction of personal property, 1,000 or more, but less than 20,000. It is a felony. Counsel, for purposes of arraignment?
Yes, Your Honor. At this time, we are prepared to waive a formal reading. My client stands mute.
All right, I'm going to enter a not guilty plea. Sir, I'm going to advise you of your rights. You do have the right to remain silent. You do not have to say anything. You're charged with a 5-year felony here. If you do say something in court or out of court, whether orally or in writing, it can be used against you. Do you understand that?
Yes, sir. Yes.
You have the right to be represented by a lawyer not only today, but at all subsequent court proceedings. If you cannot afford a lawyer, I will appoint a lawyer for you at public expense. Also, if you ever choose to submit to questioning with law enforcement officials, you do have the right to be represented by a lawyer at that questioning. Do you understand that?
Yes, sir.
All right. Would you like an attorney to represent you?
I'll hire one. I'll get one.
How about if we do this? Sometimes lawyers on felonies are more expensive than people imagine. So how about if I have you fill out a petition for a court-appointed lawyer? And
Okay.
if you go out and hire one, and I would encourage you to do that, then in that event, we will discharge your court-appointed lawyer, and your lawyer can substitute in the place and stead of the court-appointed lawyer. Is that fair?
Yeah, that's fair.
You have the right to a probable cause conference within 14 days. At the probable cause conference, your lawyer will discuss this case with the prosecutor. At the preliminary exam, if it goes that far, the people have to show that the crime was committed and that you were the one who probably committed the crime. If they prove that, you'll be bound over for further proceedings to the circuit court. If they fail to prove that, the case would be dismissed and you would be discharged. Do you understand that?
I understand.
You punch holes in this, please, right where they are. All right. So I'm going to listen, Mr. Westmoreland, to whatever it is that you'd like to say.
Yes, Your Honor. Mr. Young currently is residing in Woodhaven. He is gainfully employed at Ford Motor Company, where he's been working for over 25 years. He's not currently on probation or parole. However, he does have a matter out of Wyandotte. It's a misdemeanor charge. He's on bond with a tether. In addition, he did have court yesterday. Judge DeSanto ordered him to be placed on a tether. He went down to Wayne County to obtain that tether, and that's where he was told that he had this warrant. He was not aware of this warrant, but after speaking with him, he did assure me he would be appearing at all future court dates, has no history of not appearing. Simply, he just wasn't aware of this one, but he does understand the importance of doing so. So I just ask that all that be taken into account when assessing a bond.
Detective, I did the signing on record on this back in July. Tell me what happened.
We sent a letter to his last known address that we had for him from the victim's information, and a letter was sent to him advising him.
I want to know, was he intoxicated? What is the relationship between he and the victim, and what did he specifically do?
He damaged her vehicle. It was a former dating relationship.
What did he do? Bash it into the wall bat or what?
He broke her windshield wipers off, and I also believe one of her side mirrors.
Has he been printed?
Yes.
He has?
Yes.
What kind of criminal history does he have?
One second, Judge, stand by. I just came back here. I don't have the CCH paperwork with us.
What's the charge he's in front of Judge DeSanto on?
I believe it's a disorderly person.
Which plant do you work at, sir?
Livonia Transmission.
Do you own the house on Chipmunk?
No, it's my parents' house.
Do you live with them?
Yes, yes.
Any kids married?
I have a 24-year-old daughter, not married.
Okay. How
Your
much
Honor,
do you
the
make?
only previous.
Go ahead.
conviction on his record, his CCH is an assault with a dangerous weapon back in 2001.
How much, money do you make weekly?
40 hours, 1250-ish.
7,500, 10%. You cannot leave the state without the consent of the court. I'm not going to require a GPS on this case. You cannot violate a law. You must appear in court as directed. Absolutely no contact with Monica Lewandowski. No contact with prosecution witnesses except through your lawyer. You're not to enter the property address at 1505 Harbor Boulevard in the city of Trenton. Also, you cannot leave the state without consent. You cannot violate a law. You must appear in court as directed. You understand all of that?
I understand.
Probable cause conference will be January 27th at 9:30. Preliminary exam February 3rd at 11 a.m. You'll be in front of Judge Hessen on those. I wish you well. And make sure he fills out a petition if you would, Detective.
Thank you, Your Honor.
Anything else, gentlemen?
Not this time, Judge. Thank you.
Mr. Geez. Mr. Young, any questions?
No, I'm all set.
Detective, anything else?
No, Your Honor, thank you.
Thank you very much, everybody. Have a great day.
Thank you, Judge. You too.
Medina Renovations and Mothy. Mothy versus Carlos Medina Cartagena, 2504565. Everybody's name.
Carlos Medina, Michael Moati.
Do you guys want to go and try and talk, or do you want me to adjourn this and you can get an estimate and bring everybody in, and the contractor can tell me what he didn't do, and you can tell me what he didn't do, Mr. Moati, and you can tell me whatever you want if it's true. You know, you completed the project, 90% completed the project, or do you two want to go out in the hallway and try to resolve this? It's up to you.
Your Honor, I've tried to do that.
Okay. Well, look. I'm going to adjourn it. I'm going to give you an opportunity. I want to keep these papers here. Jennifer, I don't know what I'm
Judge,
going to.
I kept a copy for
Perfect.
for us to scan in.
So can I keep these or not?
Yes.
All right. I'm going to keep these papers. Actually, I'm going to put them on the back of the register just so I can have them next time. We're going to adjourn this. How long do you think it'll take you to get a contractor out and to take a look, Mr. Malathi?
I think 14 days I'll be able to do that.
Well, let's give you more time than that. I mean, maybe you have more success getting contractors out than I do. Let's adjourn it a month, Jennifer.
Can I comment?
Yeah.
From the paperwork he just provided, he sent the court.
Yeah.
Paperwork.
Yeah.
One of the things I see they're missing is that he pulled out the.
Okay, we're not going to go into this because there's no way I can resolve this today.
Yes. I just wanted to comment that.
You can comment on that next time. Let me just adjourn it a month. Plaintiff to get contractor bid, and we'll go from there. Can you give me a date in February?
Yes, Your
Jennifer?
Honor. We can do February 24th.
No, I don't need to go that far. We're
That
not
far?
going.
Okay, then 10th.
February 10th. And that'll be at what time?
I'm looking here. That would be at 10.
All right. And if you have pictures, you're going to give me an estimate as to how much you think you still had to complete. Okay, fair enough. And you're going to give me a breakdown, both of them, as to how much. Let me just double check something here. I mean, if you agree you didn't do the kid's bathroom at all, right? So he didn't.
You can get to start, so.
All right, we'll see you guys back on that day. Okay? Bring any witnesses you want, but I need that estimate from a contractor, and I want him to be present.
Yes.
He can be present on Zoom. I don't have a problem with that if he's busy or she's busy or whoever it is. All right?
All right,
Thank you both, gentlemen. We'll see you in 3 weeks or so. Good luck. American Express versus Robert Johnson Jr., 2502605.
Your Honor, the attorneys are in a breakout room.
LVNV versus Dawn Casey. LVNV versus Dawn Casey, 2503432.
So we're ready, Your Honor.
Good morning, Your Honor.
Your appearance, Mr. Stratton?
Yes, good morning again, Your Honor. Trevor Stratton, P65124 on behalf of the plaintiff.
And good morning, Your Honor. Sunny Miller, P8840 on behalf of the defendant, Don Casey.
Okay.
And Your Honor, there are two cases.
Okay, I wonder.
We can cover those both, or we can do them separately.
Do these, let me see, what? No wonder I see 04, I was confused because you got 03433, so I got a second one, LVNV versus Casey, 2503433.
Correct.
Everybody's appearance on this case too, please.
Yes, good morning. Trevor Stratton, P65124 on behalf of the plaintiff in this case as well.
And good morning, Your Honor. Sunny Miller, P8840 on behalf of the defendant in this matter as well.
What kind of cases are these? Can somebody tell me?
These are just small collection cases, Your Honor.
I'm going to do the same. And you guys do not have them resolved, right?
Not currently.
No, not yet, Your Honor.
So I want you to listen, Sadie, if you would, please. I got two of the same cases, same caption, except the case numbers one apart.
Yeah.
So I'm just going to do one of these. And then you'll type them up for both. Here's what I'm going to do, guys. I'm going to give you, how long do you need for this, Gary? Can you do it by March 1? March 15th of 26, I'll give you two, okay? March 15th, no jury. We're going to give you a trial date. February 15th of 26, witness lists, I'm sorry. Witness lists are due. You don't have to file a trial brief. If you choose to, you have to file, exchange it not later than 7 days before the trial date. No jury, no ADR. All motions for summary have to be filed and heard not later than 20 days before the trial date. Give me the same date. We're going to have to move this one a little bit to second week of April or thereabouts.
April 21st.
Do we have anything? Yeah, that's fine. April 21st at
10:30.
At 10:30. That's when I'm going to do both of these cases, ladies and gentlemen. Okay. So we'll prepare two different pretrial orders for you, but we'll have both trials set at the same date and at the same time. Okay. Anything else, Mr. Stratton?
No, Your Honor.
Ms. Miller, anything else?
Nothing from you, Your Honor.
Have a good day, you guys. Thank you.
I'll see you in 15 minutes, but thank you.
Okay. American Express versus Johnson, Robert Johnson Jr., 2502605. All right.
Your Honor, the attorneys on that matter, I believe, are still in the breakout room. Ms.
I thought I
Zagarev
just saw Ms.
Yeah,
Zagarev.
she lost connection.
That's okay. Credit Corp versus Affy Cobbs Jr., 2503655.
Good morning, Judge. Francesca Servi for plaintiff P87205.
Is the defendant here Affy Cobbs Jr.?
Not checked in on Zoom, Your Honor.
Counsel, I'm going to go ahead and give you a default. You can go ahead. I gave him 15 minutes. It's now 9:45. This was scheduled for 9:30.
Okay, Judge. Plaintiff will submit the default then.
I'll ask you to give me the breakdown now, if you would, please.
Oh, sure. The default are judgment in the amount of $2,722.76. So that's including damages in the amount of $2,472.82, costs in the amount of $174.94, and a statutory attorney fee of $75, Judge.
Total 2,000 what? 700?
$2,722.76.
Defendant failed to appear. I gave her 15 minutes. Default judgment centered. The amount of the judgment will be 2,722.76. You are all set. Thank you very much. American Express versus Marvin Glenn and Legacy.
Judge, I apologize, but Miss Cobb just jumped up on my screen as in the waiting room, the one you just entered the
All right.
default.
It's all right. That's okay. It's not the end of the world.
Okay,
So I'm
yeah, they
not gonna
just joined.
You got to state your name, Ms. Cobbs.
Athon Cobbs Jr.
You got to start your video, sir.
Oh, sorry about that.
All right. You just
Athon
popped
Cobbs.
open. Next time you got to be here on time. I just entered a default. I'm not going to hold you to that, but what time did you show up?
I'm 15 minutes late. I apologize.
I know. Well, next time you're 15 minutes late, I'm keeping the judgment in effect. Okay. That's how much I give everybody, 15 minutes.
All right.
Okay. My deal is you don't keep me waiting or the other parties waiting. I won't keep you waiting. Fair enough?
Fair.
All right. So what do we have here? You guys want to talk?
Yes, if we can, Judge. We haven't had a chance to speak yet.
I'll put you guys in a breakout room. You can come back. If not, I'll just give you a trial date. Okay? Thanks.
Perfect. Thanks.
American Express versus Marvin Glenn and Legacy Real Estate Service, 2503821.
Good morning, Your Honor. Michael Kirshenheider for the plaintiff, P75722. How are you?
Good morning, Mr. Kirshenheider. Do I have Marvin Glenn and Legacy Real Estate here?
No, Your Honor, I've not had either check in.
What time is this scheduled? 9:30. Okay, go ahead. Take your default.
Well, Judge, actually, so this one, I believe this is as to entry of a judgment against the defendant to the entity, but in reviewing the file, it doesn't look like this was properly filed. This is not an actual corporate entity. If you look closely, it's not. There's no LLC. It's not spelled correctly. I think it would be appropriate at this point as the defendant to simply dismiss without prejudice, and I can bring it in an appropriate fashion if necessary. But there is also already a judgment as to Marvin Glenn.
All right, so you took this was, so I just want to reiterate. You filed a motion for entry of default judgment against the garnishee defendant, right? Or not?
No. I don't believe so, Judge.
Okay, tell me what happened here. I'm just, so you took a judgment against defendant one.
Correct.
And now we got a hearing for entry of judgment again as to defendant two, but you're saying that it might, I'm jumping ahead here. I might be guessing. Are you telling me there wasn't proper service?
What I'm telling you is defendant two in the court's records is listed as Legacy Real Estate Service with no E at the end, no LLC. The corporate entity is not properly in this action. I think the corporate entity needs to be dismissed without prejudice to this point, and we will continue against Mr. Glenn as there is a judgment against him.
All right, so I'm just going to say plaintiff acknowledges defendant two not a proper party. You're going to send in a motion or an order to dismiss as the defendant two, correct?
Will do, Judge. Yep.
All right, so plaintiff to submit. Can you do that this morning for me? I'm going to.
Yeah, that should be no problem.
I'll just say plaintiff to submit proposed dismissal as to defendant two, and then I'll go ahead and sign it. And then we're on track on the other. You've already got a judgment, right?
That's correct, Judge.
Okay, thanks a lot, Mr. Kirshenheider. I'll ask you to do that today. Thank you very much. Have a good day.
See you later.
LVNV versus Angela Rohr, 2504193. Who's here on this one? Anybody here? American Express versus Robert Johnson Jr., 2502605.
Good morning, Your Honor. Andrew Tetro appearing on behalf of the plaintiff, American Express.
Ms. Aguilar, your name?
Diana Xegaravas on behalf of the defendant.
All right, good morning to the two of you. What are we going to do here?
Your Honor, the defendant is not opposing the entry of the judgment sought in the MSD. I can submit a judgment via my file after the hearing.
That's correct, Your Honor.
Give me a second. Just give me 1 second, please. All right. Court finds that there's no genuine issue as to any material fact. Plaintiff's motion for summary disposition is granted. I'm going to ask you to give me your breakdown here, counsel.
Absolutely. So the unpaid account balance, which we are seeking as damages, is $9,709.54. And we're adding court costs in the amount of $138.97 for a total judgment amount of $9,848.51.
All right. I'm going to go ahead and grant your motion. Judgment's entered in that amount, 9,848.51. I'm going to just ask that you submit your judgment this morning, if you would, please.
Absolutely. Thank you, Judge.
Have a great day, two of you. Thank you very much.
Thank you. Have a good one,
Thank
Diane.
you, Judge. Thanks, Andy.
Yep.
What are we doing on, do I have LVNV versus Roar? Is anybody here on that?
That's Miss Serby, and she's just back
Okay.
in from speaking with Mr. Cobb.
2504193. Okay. I'm going to go on to LVNV versus Roar, though, right now. Is Angela Roar out there?
No, Your Honor, she has not checked in with me.
Unless something else, Ms. Serby, your appearance?
Yes, Judge Francesca Serby for plaintiff P87205.
Willing to give you a default judgment on this case against Angela Roar.
Okay, so the total judgment amount on that one then
I want you to give me a breakdown.
Sure. Damages are $3,112.11. Costs are $113.04. Statutory attorney fee, $75. Total judgment amount $3,300.15.
Defendant failed to appear. She was given 15 minutes. It's now 9:53. Pretrial was scheduled for 9:30. Default judgment entered. The amount of the judgment will be $3,300.15. I'll ask you to submit a judgment to me on that one. Credit Corp versus Athy Cobbs Jr., 2503655. Everybody's name again, please.
Francesca Serby for plaintiff P87205.
Sir, your name again, please.
Athy Cobbs Jr.
Any resolution?
There was no resolution on this one, Judge.
You owe the money, sir?
Yes, I came up with a resolution. She just didn't want to agree on the amount that I'll try to pay a month. That's the only thing difference.
What? Do you agree that you owe the $247,282?
No, not that amount. We came up with a lesser amount. It was more like $2,200. I can't remember the exact amount. And we came up with a payment plan to pay a month. She didn't accept it. So now we're back here.
So Judge, we did not come up with anything. He offered a $20 per month payment towards the balance, and I advise that's too low for my client to accept.
Where do you work at?
I'm at Chrysler.
And you want to pay $20 a month?
Hey, right now, I got
how much? Hang on, slow down.
Right now, I'm in your okay, Kevin.
So, what plant do you work in?
Toledo.
You're making $30 an hour, right?
I make more than that, but I'm telling you, I'm in and out your courtroom every other month with these people trying to come up with money from the past. It's only so much going around, I'm giving them, offering them what I could. They're being greedy on it. I don't even agree with the amount that the interest that has occurred over the time. I've given them an amount. Any other credit, a couple of months I was in your courtroom, everybody else accepted the offer that I've been paying. So I don't know if we go back in the system, I don't know what's wrong with these people, why they can act like they can't accept it. But I never had any problems before. I've been to your courtroom like 3 or 4 times with the same situation. Never had a problem before.
You're not doing a very good job of managing your money, Mr. Cobbs. I don't know what you're doing with it, but
I understand that, but things happen. You got student loans coming out, all type of stuff is hitting you from the past. It's it's just life out here. I'm making good money. I make a good living, but like I said, it's only so much I could go around. I'm not one out here that's not working. I'm working. I'll make a good living, but it's only
Slow
so
down.
much to go around.
Slow down. Just slow down. Let me make a suggestion to you, okay? If you owe the debt, you owe the debt. If you don't owe the debt, you don't owe the debt. But I have a feeling you owe the debt based on what you're telling me.
I agreed. I owe the
Hang
debt.
on. Let me finish. If you owe the debt, what point is there? It's like losing a football game 90-3, and there's 2 seconds to go, and they've got the ball on their own 2-yard line. I mean, if you owe the debt, what's the point in fighting? Now, I can listen. Listen. You're interrupting me. Please don't do that, Mr. Cobbs. Just listen to me. If you owe the debt, you owe the debt. And if
I
you
agree with you. I'm not fighting.
Mr. Cobbs, would you please let me finish? That's about the 3rd time at least that you've interrupted me. Okay,
I apologize. I thought it was done.
just let me finish. If the two of you agree that you owe the money and you're only willing to pay $20 a month and they don't think that's enough, let me just suggest that the two of you enter into a consent judgment and then we'll have an installment payment hearing right now. And you can tell me, I'll swear you to an oath. You'll tell me what all your bills are, and I'll make a determination. Nobody wants anybody to go into bankruptcy here, but I have to say, on its face, $20 a month for a guy making $32 an hour, just on its face, is not enough money, right? I mean, you earn $20 in 30 minutes after they take out taxes practically. So come on. You got to be a little bit more reasonable. If that's, just please listen. I'm going to just make a suggestion. If you guys want to keep coming back, that's up to you. I could care less. I'm here all day anyway. Do you understand what I'm saying? If you owe the debt, it doesn't make any sense to fight over the debt. You can fight over the installment payment order, and I will listen to everything you say. I'll swear, if you guys want to tell me, Judge, we're doing a consent judgment, and then a separate installment payment order that the judge is going to determine right now without a motion fee having to be filed by you at $20, Mr. Cobbs, I'll swear you in. You can tell me every single bill you have. You can tell me how much you make. I'm going to ask you questions. I know you wouldn't lie because you know you're in a courtroom and you know I'm going to have sworn you in and you understand that this is the best branch of government in the world right here in the United States. Okay? Not close. So I'm just telling you, I'll listen to you. I'll do what I think is right, but it doesn't make any sense to fight if you already lost the game. You follow me?
I'm with you. I'm not, like I said, I'm not fighting against anything. We had a little discrepancy on the actual amount, but that was it. They just, she just didn't want to accept the,
well, you want to buy it down. They don't want to buy it down. You use the money. I understand. I'm so glad they're talking about lowering credit card rates. There's talk of lowering them to 10%, and nobody will be a bigger fan of that. I've been saying that since I started here in 1995. But you probably have somewhere in the neighborhood of about 26% interest. What's his interest rate on this, counsel? And if you want me to be honest with you, Mr. Cobbs, I think it's borders on thievery, except they're legally permitted to do that now. But I'm not a fan of that, but I can't change it. I can't sit here and play God and make my own rules.
The interest rate APR on this one, Judge, is 29.99%.
29. Well. Okay. I was wrong. I was low. Shocking. I mean, it's ridiculous. We all know that. Anybody with an IQ over 3.5 knows that. So I'm not against you, Mr. Cobbs. I'm just telling you there's nothing I can do about that. So if you want to calculate the interest and come back in half an hour and write down all your bills, I'll ask Ms. Servey to come back. I'll go on to other cases and you can tell me, Judge, their calculation at that interest rate is wrong and here's why and here's the exact amount that I owe. You want to do that?
like I said, we came up to the agreement amount that I owe, but the problem was a monthly payment. That was it.
Well,
we
okay.
got it
How
down.
much? Okay. I misunderstood that. How much do you agree that he owes?
We came to a settlement of $2,253. And I offered if we would be looking for at least $60 per month payments, which in plaintiff's opinion is more than reasonable.
In what?
In plaintiff's opinion, is more than reasonable to ask for $60 per month towards that
Okay,
balance.
but can you, so are the two, okay, maybe I misunderstood. I jumped the gun. I apologize. Did the two of you agree, Mr. Cobbs, to a total settlement agreement of $2,253?
Yes.
And you agree that you owe that amount?
If we agreed to it, I wasn't fighting it. I said, okay, I owe something. I wasn't really informed of what I owed. She went down. I believe it was more around 1,500, but
All
okay.
I want to know is, are you agreeing to that
Yeah, I
amount?
agree. We agreed to 2,000. We agreed to that amount.
All right. And you're going to prepare a consent judgment in that respect, right?
Can
Ms.
you repeat
Serby?
that?
Yeah, if we come to a payment agreement, yes.
Well, I'm going to do it separately. They shouldn't be tied in. Payment arrangements versus, he doesn't have to agree to $60 a month. I'll make a decision. I'll listen to what he has to say. I'll swear him in. And I'm not saying that on its face that you're wrong, but I just want to make sure, first of all, that everybody's agreeing to a consent judgment in the amount of $2,253, with the understanding that I'll then conduct in a hearing on an installment payment order, and I'll listen to what he has to say. I'll listen to what you have to say, and I'll make a determination. But that's not going to affect the consent judgment if you guys agree to that. In other words, there shouldn't be tied in aspects, installment payment order, if he pays 60 a month or 20 a month or 5,000 a month. I mean, do we agree with that?
Yes.
No, Judge, that wasn't plaintiff's position in the breakout room. We would agree to settle for $2,253 on monthly installment payments. But if there was a default on any of the installment payments, then plaintiff would be looking for the full amount we claimed in our complaint. So it wouldn't necessarily be that the total judgment amount we're looking for entry would be $2,253. That would simply be the settlement.
So what she's saying to you, Mr. Cobbs, what's the total amount of the judgment if you didn't give him a reduction?
$2,722.76.
So, sir, listen to me. I got a bunch of people waiting here. Okay, so I don't want to spend too much time here. I'll spend all the time I need if you want to come back. But what she's saying is that you owe $2,722.76, but they're willing to compromise and make it $2,253 if you pay 60 per month and you stay on those payments. Am I understanding correctly, Ms. Serby, that if he misses a payment, the original amount of the judgment is going to be entered less any payments received?
Yes, Your Honor, that's correct.
Do you understand that, Mr. Cobbs?
Yeah, I understand what you're saying right there.
60 a month, I'll just set it for trial. I can't, unless you want to agree to 2722.76, in which case I'll have this hearing that I talked about. But I can't get in the middle of your agreements here. I mean, trying to help you resolve it, it seems silly that we're still going. But if you don't think you owe at least 2253, you can't pay 60 per month, then I'll just set it for trial.
Like I said, we left the room agreeing on the amount that I owe. It was just the payment.
Sure. She's tying it into 60 a month payments. That's what she's doing.
Right, and she told me she was going to
I'll give you a discount of almost $500 on the judgment if you agree to pay and do pay 60 per month. If you can't do that, then we're back to square one. I could care, gentlemen and ladies.
Yeah,
but I'm not going to argue with people. I'm not going to get involved in this any more than I already did. 20 a month is ridiculous. I got to tell you, on its face. You're working overtime. You're going to get a bonus here too. Come on, right? How much is your bonus going to be? I heard they're a little lower this year, but how much your bonus going to be? You know,
I'm not sure. Yeah, I'm not sure right now.
You guys get thousands. I know. Come on. It's
like
good.
I said,
I'm glad for it. I'm happy. I hope they give you 20,000, but that's not the point. Are you guys going to resolve this or not? If you're not, fine.
I want to resolve it. I'm trying to.
I know, but I'm not going to spend all this time and keep all these people waiting. You guys go back into a breakout room, and then I'll have you out in 10 minutes, and you guys can tell me whether you resolved it or not, okay? That's the
All right.
best I can do. Thank you. People against, Gloria Marie Neese, 22F238120. Come on up, Ms. Neese.
Where?
Your name? Out of curiosity, what brings you here?
Okay, so I moved to Florida like 5 years ago.
You what?
Yeah, to take care of my grandfather. Well, I came back, I'd say about 3 weeks ago. I was pulled over in the car with my cousin, and they told me I had a warrant in the city. Well, it was Christmas, so I was gonna do that because I didn't know like what was gonna happen. I went to the police station to turn myself in on it to try to get on some type of payment arrangement because I'm a traveling nurse, so I can't work my job.
Slow down a second. Are you telling me this wasn't you that was pulled over?
No, it was.
So you were pulled, no, I'm talking about in July of 22.
But it was on the Walter Road, right?
Well, Carlton, near John Street, John L. Street. in
It was
Flat-
a Black weekend?
Yes.
Yeah, that's my ticket. I didn't live here at the time. I was visiting.
Okay, well, what are you asking me to do? You
I
show,
just need like some type of payment plan until I can.
ma'am,
I don't know how much the ticket is. I don't know what it like.
Ma'am. Why didn't you show up for 3 years?
I didn't live here. I honestly got, but you know, I can show you on my phone that my Facebook.
Care if you were living in Tuscaloosa? I don't care where you were living. You don't do this. You're a traveling nurse and you're acting this irresponsibly? I'm serious.
It just.
Ma'am, you got the ticket. You knew you got a ticket. When I see the lights go on, if I get worried I'm speeding.
Oh, I was speeding today.
We know. And we also know you've been ignoring the courts for 3 years. Why am I going to give you a payment plan when you haven't been here in 3 years? All you had to do was come and talk. Like when you do your job, right? You expect people to show you a little bit of respect. I don't care if they show me respect. I do care if they don't show the system respect. Because I'm just a guy sitting here for a while. I'm running the seat. You know what I mean?
Yep.
Now, you're going to have to come up with this money. I'm not going to give you a payment plan on something that's 3 years old. If you picked up one pop can a day, you'd have had this paid 2 years ago. I mean, I get a little tired of this. If you're a traveling nurse, you're making good money, right?
Yeah, I do make them.
Then why didn't you take care of your ticket?
I didn't realize the ticket was like an active ticket.
What did you think? They threw it in the garbage after they gave it to
When
you?
I called the courthouse to try to set up a court date for the ticket, they told me there was no court date for the ticket.
Because you'd already gone into the phone. It's like if a football team doesn't show up to that's playing today, they forfeit, they lose. You didn't do anything. Call someone, get the money, and then we can be done. I kind of take offense that you're coming in here 3 years ago as a traveling nurse. Now, let me tell you something. If you were a single mother on a bridge card that was unemployed and you had 3 kids and the father wasn't in their lives, they might be a different story. Okay? You got a credit card that can help you pay this today, right?
Okay.
Then why don't you want to go down the hall and pay? You want to come in?
I just don't want, like, Christmas just happened, my kids, like, I do have a life and I'm reestablishing my life here, so I was just trying to do the right things, but to be able to do them to where it's affordable. But I mean, if you want to pay it all today, I'll pay it.
What I wanted was you to contact us 3 years ago and show a little bit of respect.
I understand.
Somehow, some way, I have a hard time understanding why people don't show the judicial system respect. I have my answers that I will tell my closest friends. But we're in the best branch of government in this country. Now that is not even close in my view, and I don't care who says what and what they say. So I take offense as a member of the judiciary when somebody doesn't show up for 3 years, doesn't bother to make a phone call and say, hey, I got a ticket a month ago. I went into default. How can I pay this? In which case they would have told you, zoom in from Naples or Sarasota or wherever you are and the judge will give you a payment plan. That being said, I'm gonna hope this little discussion's gonna clear some things up. I'm gonna hope that next time you get a ticket, you're gonna be a little bit more respectful of the system. That being said, you tell me, take your hat off, sir. Tell me how much you can afford to pay and when. We got a tax. Is there a new tax garnishment on this? Can somebody tell me, or I don't think Lisa's here. Go ahead.
There is,
Well, they filed one in 22. Tell me how much you can afford to pay and when.
right now, I'm actually, so.
Tell me how much you can afford to pay and when. I don't need to hear any explanations. Huh?
100 this month and pay it off next month, if that's okay with you.
What, can you pay 100 by the end of the month or not?
Yes,
You sure?
yeah.
I'll give you more time if you don't need, if you need. You pay 100 by January 31, balance by February. I don't know if there's 28 or 29 days. There's 28 in February this year. So we're going to have the balance paid by February 28. Now, if you don't have the money, you call the court, go on Zoom, I'll give you an extension. If we have to do that for the next 17 years, I don't really care. Okay, fair enough?
No, I appreciate it, because I can't get my license transferred to here. They won't let me work here unless I take care of this stuff, like.
Because you
So it's
dropped the
not-
ball, you're not acting like a traveling nurse. I mean, that's quite a response. It's a big response. Okay, good enough. That's what we'll handle. Are you telling me you can't work until you pay this?
Yeah, I can't work until, no, I have to have the warrant dismissed.
Yeah, I know. That's why you came in here. I'm telling you, you miss a payment, we're gonna have a big problem. I will send you to jail. Do we understand one another? Do you understand one another? Like, I've got some wise guys that come in here and do this with me. And they get the warrant lifted, and then they think everything's gonna be all right. Whoa, I pulled one over. Don't pull one over on me. I'm telling you, what's their cause? All right, you make sure. Good luck. Thank you. People against, or Discover Bank versus Artemis J. Petty, 250-094. You didn't do that on purpose, right? You would never have done that on purpose. Come on up here, sir. Your name?
Artemis Petty.
I'm not sure what brings you here.
Sir, I have a payment plan with Discover. I am up to date on the payment plan, but we were haggling over the first month. When you made a judgment on this payment in May, I didn't receive.
You got to file a motion. You can't just, did you file a motion?
There's an objection, Your Honor.
Oh, do I have the other side here?
Yes, Mr. Stratton is here on this, I believe.
Mr. Stratton, come on in, please. Wait a minute, maybe I'm checking, do I have that paperwork, Jen? Objections to garnishment, I see. All right, good morning, Mr. Stratton, your name?
Yep, good morning, Trevor Stratton, P65124 on behalf of the plaintiff.
Your name again?
Artemis Petty.
Okay, so wait a second. Did you read his objection? I'm not quite understanding what he said. Do you agree with do you agree with him?
Your Honor, I only heard a few seconds of what he had to say.
Repeat what you said, sir.
I said that I'm here today to, I'm objecting to the garnishment. I am up to date on the payment plan, but they issued the objection due to me not paying the first month in May. And that was due to counsel not sending me the information. Per the paperwork, all of my payments have to have the Weldman Wise account number on it. When I received the paperwork, I started paying, but they felt that because I missed that first month, I'm already in default. Now, I do want to say I made that payment, and I just object to that garnishment, and that's the only thing I'm here for.
All right, let me take a quick look at the judgment. Because they didn't send you the paperwork didn't mean that you didn't have to send it right after, right? You should have saved, just hear me a second. You should have saved the money and paid it on a timely basis, right? You agree with that? Can you just agree with that, or you don't want to agree with that?
Yes, I agree, Your Honor.
Okay, fair enough. All right, now let me take a look at the judgment here. All right. So he was to pay $266 commencing on or after May 20, right?
I believe so, yes.
court if we